Next up in our speaker series, Alan Yacoubian, partner at Johnson, Yacoubian and Pacey Law Firm and General Counsel for the Louisiana Restaurant Association, with its workers' compensation program, will be talking about the recent changes in Louisiana law with a focus on what can help your business prosper and what may present a challenge if not properly accounted for in advance. Please welcome Alan Yacoubian to the stage.
Thank you. Please hold your applause. Good afternoon. I'm Alan Yacoubian, and I serve as General Counsel for the Louisiana Restaurant Association. And let me start off by saying it's an honor and privilege to be here today, to be part of this great trade show. And I'm going to try to get the mic up a little bit because I've seen some of the previous speakers. It's kind of hard. So we're really excited to be here today, and I appreciate there's a lot of competition for your showcase dollar. So those who are out in the audience, I appreciate you being here. I'm going to do the best I can to make sure that this is a very informative session for you. Let me start off by thanking LRA Chair Octavio Mantilla for all of his services past year, and then the Showcase Chair, Mr. Brad Watts. And I'd also be remiss if I didn't thank the entire LRA staff, starting with President Stan Harris, and of course Wendy Warren and Pam St. Pierre, because they just do an amazing job. I see them way back there because it's really hard for people to come up to this stage. I realize it's very crowded. We're a little bit overwhelmed by the number of people, but we're going to get through this. Having said that, we think that we have a very timely and informative program for you because we believe that it really speaks to the current state of affairs in Louisiana and the future for our state, for our children, for our businesses, and where we see ourselves going. Now, I would love to take credit for doing this entire presentation on my own, but I think most of you would know better than to think that I could do that. So let me go ahead and introduce Andrew Davis, who serves as senior counsel in our firm. Andrew basically was the man that did all the work, the laboring oar, in putting this together. And so I want to thank Andrew, and I'm happy that he's here today because I'm not going to stand up here at this podium the entire time. I'm going to let Andrew take on a lot of this. So with that said, let me talk a little bit about why we're here and what we're going to talk about. This presentation is on recent developments in Louisiana law, the good, the bad, and we've kind of made the title more accurate, the nuclear. And so when we talk about all that's been going on these past two legislative sessions, what we see is that there are a lot of good things, a lot of things that have taken place that all of us should feel good about when it comes to running our businesses, looking at our insurance rates, and I'm going to add, looking forward to having, you saw these young high school kids, we don't want them to leave Louisiana and never come back. A lot of us have kind of suffered that plight. And I have to tell you that our goal as a state is to make Louisiana attractive for our families to stay here and prosper in this state. So when we look at recent developments in Louisiana law, we're going to talk first about the good, then we're going to talk about the bad, and then finally the nuclear. So with that said, let me start off and talk about the good. The good is the tort reform and the insurance reform that's taken place in Louisiana. Those measures in the past 2 years have seen a major decline in the rising insurance rates in our state, starting with the property insurance, which I know you all having your homeowners policies, you see that all the time, and then the private passenger auto insurance, the cars that you drive. And finally, the commercial. The commercial is kind of lagging, as you would expect, because you're talking about all those big rigs on the road, all those major heavy industrial trucks. So that's a little bit harder, but we feel very good about where we are in terms of seeing insurance rates decline. And when insurance rates decline, you also see a decline in the filing of frivolous lawsuits. because they kind of go hand in hand. You wouldn't have high insurance rates if people weren't getting sued all the time. Last year, we were here. I don't know how many of y'all were around, but it's interesting. Andrew and I were talking about last year's session, and the LRA had one of their top insurance agents, John O'Brien, and he was asked, John, how have things changed in the last 25 years? And John said, well, you know, 25 years ago, we would have accidents. And there'd be an accident, and then maybe a couple weeks go by, and we move on. Now, every time, and I'm quoting him, every time we have an accident, we have a lawsuit, and we have a policy limits demand. That is impossible for any company to be able to sustain its business if every time there's an accident, they're going to get sued. And so when we look at some of the recent changes, the first one that I want to talk about is Louisiana's direct action statute. I don't know how many in our audience know what that is. I will tell you that Louisiana is one of a very few number of states in the country that have a direct action statute. A direct action statute is a statute that basically provides that an injured party can sue a third party's insurance company directly, not after the fact, not to recover on a judgment. And you all may say, well, okay, why is that a problem? Well, it's a problem if a jury, number one, sees in the caption of the lawsuit that they're really not returning a verdict against your neighbor. They're returning a verdict against your neighbor's insurance company, what we like to call a faceless victim. The insurance company's not there really to defend themselves. Yeah, they've got lawyers that are hired to represent the insured, the policyholder. But at the end of the day, there's a feeling that I'm not suing my neighbor, I'm suing my neighbor's insurance company. So I don't feel bad about it. If I'm going to take my chances and see what I can do by way of a recovery, I'm willing to take my chance because at the end, I'm not going after my neighbor. But what we have all learned, it's not that simple. It's not that simple at all because it affects your rate. When you're sued and you're found liable, your loss record changes, your loss ratio changes, and you become a bad risk. So the idea that no hard feelings between you and me, I'm just suing your insurance company, became extremely overrated. So in August of 2024, this new law went into effect. And what it did was it took the direct action statute. There's only 3 or 4 states in the union that even have it. Wisconsin's probably the worst. They have it in Georgia, but Georgia's kind of limited. So in Louisiana, it goes back to what I think its original intent was. And that is that only under very narrow circumstances can you sue a third party's insurance company. It's either got to be that the insured is bankrupt, insolvent, you can't get service on them, there is some issue about coverage where there's a reservation of rights letter, something that creates an exception that allows for it. What's very important about this change in the law is that no longer will a jury know that there's insurance. So I'm going to say a couple times during this presentation, justice should be blind. They say justice is blind. Justice should not know that there's insurance out there that allows for a recovery, and this is how much there is, and therefore I'm going to go ahead and find the other party liable and for this much money because that's how much is in insurance, or do the same by way of a settlement. So this change in the law basically, I think, levels the playing field. It means that each party has to prove their case and prove their case in a manner that's fair and reasonable in the premises. We're going to talk about nuclear verdicts towards the end. Nuclear verdicts are verdicts that are rendered that are in excess of $10 million. So let me go now to the next major change in the law, and that is Louisiana's comparative fault statute. Really important, because this law is really what defines the playing field when it comes to civil litigation involving third-party tort actions, meaning personal injury cases against a third party. The way the law used to be before this amendment, we had in Louisiana a pure comparative fault state. And what that meant was that you look at the fault of all parties, and it doesn't matter if the injured party is 98% at fault. They get to recover their damages. They'll be reduced, but they get to recover their damages. So imagine a situation where you have a party that is predominantly at fault for an accident, and they're allowed to sue you, and they're allowed to recover even though they're really the main reason why the accident occurred. That seems unfair. So now the new law is that if you are 51% at fault or greater, you can't recover anything. Zero. Zero. Now, if you are found 50% at fault, your recovery is going to be reduced commensurately with that percentage of liability. I think that's fair. And I can kind of point to why, looking at the law and the history of the law, that it seems fair to me. Back in 1980, Andrew, were you around were you born in 1980?
I was a little baby.
You were a baby. I'll take baby. I know Will over here is probably, no, he's shaking his head. He wasn't around, so you'll all have to take my word for it. Back in 1980, they changed the law. Before that time, in Louisiana, we had what was known as a contributory negligence statute. And that provided that if the injured party was 1% at fault, 1%, they couldn't recover anything. I want you to think about that. 1%, you get nothing. So imagine what kind of effect that had on lawsuits. All the defense lawyers like myself, all the insurance companies, they wanted to send every case to trial because they had nothing to lose. If they tagged the injured party for 1%, they go home with a big victory. It's a win. So they took the law and they said in 1980, we're going to make it fair. We're going to have a pure comparative negligence statute where everybody's fault will be taken into account. And even if the injured party is 99% at fault, that's okay. So I would tell you that the pendulum swung from left all the way to the right side. And what it meant was that it was, as I would tell you, open season for lawsuits because there was no disincentive to not filing a lawsuit and to not going to trial. If I know that I find the other side 99% at fault, but they still can recover from me, that sounds to me like a risky proposition. And that was what the problem was. All the trial lawyers out there, all the billboard lawyers out there, they'd take any case. And that's what we talk about frivolous lawsuits. They'd take anything. Why not? I got nothing to lose but time. So they would file lawsuits all the time. And we'll talk about that statistically. I want to make sure that we are responsible in this presentation. And it's not about opinion, it's about fact, it's about numbers, and about data. So having said that, they changed the law, and now I would say that we're at the 50-yard line of fairness. Because if the injured party is found 51% at fault, they get nothing. If the injured party is found 50% or less, then their recovery is going to be reduced to the percentage of its fault. That seems to me to be very fair. Finally, before I turn the stage over to Andrew, let him pick up, I'm going to talk about one other change in the law. Unauthorized aliens involved in motor vehicle accidents. So think about this, unauthorized alien, illegal alien, whatever term you want to use. prior to this amendment in the law, in Louisiana, an unauthorized alien or an illegal alien could file lawsuits against anyone just like you and me. And I'm not casting dispersions on those folks at all, but I'm simply telling you that in the law, it was considered to be unfair that someone who's not in this country properly has a right to sue if they're involved in an accident. So what the Louisiana legislature decided to do was to promulgate this change in the law, providing that an unauthorized alien cannot recover general damages, which is the pain and suffering, cannot recover lost wages, because in their mind, if you're not in good standing, you can't file such a lawsuit. The old adage, you don't go to court with dirty hands. Now, the one caveat is that they can recover medical expenses. And I would submit that that's probably fair, because ultimately that's going to be the cost of a doctor or a hospital, emergency room. So I can see why they had that exception, or at least that limitation as to how far this prohibition was going to go. Now, one final comment about this statute. An unauthorized alien is basically a person who is unlawfully present according to federal, in the U.S., according to federal immigration law. So it's not some, concept, it's statutorily defined. I think it's fair. And with that, I'm going to let Andrew talk about some more of the good. He's going to talk about no pay, no play.
Okay. Does anyone here know what no pay, no play is? If you don't, it means if you don't pay your insurance, you can't play the personal injury game. Louisiana originally passed the no pay, no play statute in 1997, and it was to penalize drivers without insurance so they could not recover the first $15,000 for bodily injury and $25,000 for property damage. And this was an effective deterrence for a while. Small accidents, it wouldn't be worth it to bring a claim, and no lawyers would touch it. But with inflation diluting the effectiveness of this law, and with bigger and bigger judgments, lawyers weren't risk averse to taking these penalty cases because it would be worth it to do it anyway. So the new penalty for not having minimum liability insurance is you are not able to recover the first $100,000. You can see here's a statutory text. And not that you want this to actually happen to you, but there are a few outs where the law doesn't apply. And basically, if the other driver is doing something illegal, if the other driver is drinking and driving, if the other driver intentionally caused the accident, if the other driver flees the scene of the accident, or if the other driver is committing some sort of felony. And then there's another very strange circumstance where this law would not apply. If the other vehicle is not being operated by anyone, and you're not in violation of the traffic laws, this would not apply. You can imagine a car falling off of a second-story garage or something. I don't know. And the other thing that this law allows you to do is if somehow someone who does not have insurance still takes this to court, still takes this to trial, the other side can use it as a defense. And if this plaintiff doesn't have insurance, and they get to the end of the trial and they get less than $100,000, they get zero, and they have to pay for everyone's court costs. So they not only have to pay for their own court costs, the insurance company's lawyer who set it all up and brought in all their experts and got everyone testifying for a week, the person without insurance has to pay for that too. And you can imagine they probably can't afford it if they don't have the insurance also. So, all in all, the penalty was cranked up to something really serious, and drivers without insurance will have to suffer a six-figure penalty before they recover a single dollar. And look, it's not fair to the public. It's not fair to the public to be driving around without liability insurance that we all have to pay for. We're all obeying the law, and someone's driving without this. And this provides a serious deterrent from such conduct. Okay, recoverable medical expenses. So imagine you're in a car accident. Maybe it's your fault. Maybe the policeman says it's your fault. And for whatever reason, the matter can't get resolved and you go to trial. And you have to go up there and the other people have to go there. And you're sitting in the gallery and it gets to the point where they're submitting the medical bills. And they say, here's what the bill is. But they don't tell the jury what they actually paid. And the bills are grossly inflated. And how unfair is it? They're presenting numbers that they didn't actually pay. But this is what the old law was, and it was called the collateral source rule. And the idea behind it was a person shouldn't be punished for having health insurance. And that was the idea behind it. No, you shouldn't be punished because you were able to get health insurance to defray medical costs should you get hurt. Well, this has changed. And now people have to present both the bill and what they actually paid so that the jury will decide you get the money that you actually paid for these medical bills. And this reform is just simply about fairness. Plaintiffs aren't being stuck with medical bills they can't pay for. To the extent that the plaintiff's medical bills were actually paid for, that's what the court awards. And anything more is a windfall. And one last thing. Whoops, I went the wrong way, guys. I apologize. And one last thing, if you have a medical malpractice claim, if you have an injury from the place you sought treatment from, this law does not apply. And it also doesn't apply if the insurance policy has medical payment coverage. All right. Does anyone here know what the Housley presumption is? Anyone know? It sounds like something from law school or a legal drama, where the older lawyer's scratching his chin and the younger lawyer pipes up and says, "Sir, what about the Housley presumption?" And the light bulb goes off and everyone moves on. Well, also imagine you're in a car accident and someone sues you and they're alleging all sorts of injuries. And when the plaintiff goes up onto the stand in the courtroom and they testify, well, I felt fine before the accident and now my neck hurts all the time. That's the Housley presumption. That's all that they have to do, believe it or not. And that's what the Louisiana law was for the last 35 years. Basically, the plaintiff didn't even have to prove that you caused the injuries. The court would say, okay, if you felt fine before the accident and now you're hurt, there's a jury instruction that said, you as a jury have to presume that these injuries came from the accident. And now we just talked about comparative fault and how that opened up the gates for litigation. Here you have a car accident, you get some medical records, and the plaintiff is guaranteed a substantial judgment. So the new law is the plaintiff has to prove their injuries the old-fashioned way, with evidence and testimony. Again, this is not putting a thumb on the scales of justice. This reform removes what has become an unfair advantage for certain plaintiffs and tries to bring the courtroom back to something resembling a level playing field. And all the plaintiff has to do is prove this with a preponderance of evidence. That's just more likely than not. Same with everyone else. And just to make sure no one gets left out in the cold, this only applies to accidents that happen after May 28th, 2025. All right, I'm going to return this back to Alan, and he's going to talk about what has or has not happened with workers' compensation law.
Thank you. All right, I'm back up here. So when we all got together in our firm to get this presentation going, I asked everybody, I said, hey, so what's bad when it comes to Louisiana law and recent developments? What's happened that we need to report to everyone, this is bad legislation? And the truth is, we really couldn't come up with anything. We were all kind of like, well, somebody came up with some statute about permits for hunting alligators. I mean, nah, that's not going to really work. It got to the point where we really were, scraping the bottom of the barrel. But don't think that what I'm going to talk about right now is scraping the bottom of the barrel. It's just looking at this a little more intuitively in terms of reality. So because something doesn't take place in Baton Rouge, because good law or any law isn't passed, doesn't mean that things aren't bad. And so when we come to our category of the bad, what is bad in Louisiana right now, as we sit here today and talk to you all about recent developments in Louisiana law, is the fact that there has been no meaningful reform when it comes to workers' compensation law in Louisiana. Nothing has happened. In fact, we were talking, nothing's happened in the last 2 years. I would submit that nothing meaningful has really happened since Governor Mike Foster. Another reference point. Andrew, were you around for Governor Foster? You probably didn't vote for him because that would have been, a juvenile vote, huh?
I was not around.
No. So if you all say to me, okay, so you said earlier you were going to kind of talk the facts, you weren't going to talk opinion, kind of sounds like you're talking opinion. How bad is it? How bad is workers' comp in Louisiana? Well, if I told you that Louisiana, according to one study, has the highest average total cost per claim for a workers' comp claim at $67,415. What does that tell you? Again, the highest. And when we talk about all the studies we've seen, I don't think anybody at this trade show, anybody in this state could debate the fact that Louisiana is the highest state in the South. Highest state in the South, no doubt about it. Mississippi's got nothing on us. Texas, nothing. Arkansas, Alabama, you go where you want to go. Now here's my point about why is this important to you all? Because I know we're just workers' comp lawyers, we've got skin in the game, and we're kind of hypercritical. Because think about the states that your kids are moving to for jobs. They're moving to the states where workers' compensation is not as costly, where the workers' compensation laws are more reasonable. And so when we look at why is this important, why should we all care? Number one, to run your business, but number two, to keep your family. And when we look at what is causing this, mass exodus of people, this outgrowth of population in Louisiana, it's the inability to attract businesses. We go back to the auto insurance, we go back to the commercial liability insurance, but we cannot escape the fact that in Louisiana, the cost of a workers' compensation claim is much higher today than it was 20, 30 years ago. And so you ask me, well, when you say that, what is it about a workers' compensation claim that is so challenging? It's the fact that medical expenses now make up more than 50% of a claim, greater than 50%. And you'd say, well, why? How come the treatment versus, they're out, they lost their wages, they can't work? I thought it was all about the inability to work. Well, in Louisiana, we have a fee schedule that has not been updated, amended, modified, whatever term you want to use, for over 30 years. Let me say that again, 30 years. I want you to think about this. Think back 30 years ago and kind of move forward from there. What kind of medical innovations have taken place? What kind of streamlining of treatment has taken place? What kind of new advancements do we have in that whole field? How is it possible that a medical fee schedule that dictates and drives the cost of medical care, how is it possible that that wouldn't be updated? I just saw the other day, we all travel, we all have to submit expense reports, and every year the IRS updates the mileage rate. Every year. Makes sense, right? The cost of fuel, it fluctuates, usually it kind of goes up, but every year they update it. This year, they updated it in July. Now it's up even higher. I think it's 76 cents a mile. I say that to make a point, and the point is, how is it that you keep current on the cost of fuel and mileage? I understand it's simple, maybe, but you cannot update a medical fee schedule. To me, that's the biggest challenge. So when we look, though, I want to be, fair about what happened in this past session. We did have a few laws, and I think let me get to my little materials here, because I have to actually look at it, because it's nothing that I think is memorable, but yet it's something that I think I have a duty to just bring to your attention. We had Act 760, I think it's 6. Let me go to that part. Yeah, 766, which is this mandatory medical database provision. All it really does when you go through it is say, guess what? We're going to start requiring electronic billing. And you all say, well, why are you being so negative? Well, the amount of the bill doesn't change. Just the way it's delivered to you changes. Oh, but we're going to study. We're going to study. When you hear the government say we're going to study, that's code for kicking the can. We're going to study the cost of medical care to see whether or not we can now develop a fee schedule. Oh, by the way, we're going to pledge that we're going to update the fee schedule by 2029. That's not very encouraging. So when we talk about the bad, that's the reason why we have that in there, because in our mind, not a lot's happened. And I thought it was interesting. The one act that they talk about, Act 648, now allows the employer to have the same rights to sue the injured worker as the injured worker has against the employer. You say, okay, where are you going with this? To me,
Chef Tony Rodrigue will begin his oyster demo.
I know Tony Rodrigue.
Cooking demo stage.
I'm going to go see Tony. I'll be back.
And Southern Glazers. The stage is located on aisle 300.
I feel like I'm in an airport. So here's what's interesting about that particular provision. They're all excited. They say it's fair. I want you all out there who aren't lawyers, all the folks out there that are employers or just citizens of our state to think about it. All they're doing in Baton Rouge is allowing both sides to sharpen their blade. Because when you talk about the ability to file a lawsuit, all you're really talking about is the ability to wage war against each other. And I saw a recent post by a lawyer that I know, I have respect for her. She's a trial lawyer, but she had all these ideas about reform, and all it was about was the ability for us to be more streamlined in how we wage battle on each other. It wasn't really, it could be argued that it was to lower costs, but it really wasn't about lowering costs. It was about perfecting the battle of conflict. In my mind, that does not reduce workers' compensation costs. It doesn't represent reform. I'm going to now talk, before I let Andrew come back up here and introduce to you, I'm going to talk to you all about what we call, in this presentation, the nuclear. The nuclear is not a term that I came up with. It is a term of art used nationally to reference certain jury verdicts. And those are verdicts that are in excess of $10 million. $10 million or greater. When Andrew goes through some of these cases, I think you'll appreciate why that is important to understand. But I'm going to give you the statistical background of it all. Number one, Louisiana is ranked in the top 10 in the nation for being and again, a term of art, judicial hellhole, because Louisiana has one of the largest percentages of nuclear verdicts in the country. You say, well, whoa. Back that up. 135 cases in 2024 with nuclear verdicts, and that represents a 52% increase. So we're not trending in the right direction when it comes to nuclear verdicts. When you see some of these verdicts, you're going to really understand where we're going with this. Louisiana courts have awarded $436 million in nuclear verdicts in 2023. In 1 year, $436 million. So although we are bringing tort reform back into our state like we did back in the 80s, there's a lot more that needs to be done. I think Andrew now will talk about some of these verdicts. I know we're kind of bumping up on our 1 o'clock closing. So with that said, you got to go fast on this.
Yep. All right, so there's some pretty interesting cases here, and I know we're running out of time, so I won't bloviate too long on each one. But the first one we have is Valdivia versus Brock Industrial Services. This is the single largest judgment for a single plaintiff in the history of Louisiana, $411 million. Now, this case should have never gotten out of workers' comp. It's an industrial accident where a man was trying to lift a 20-pound pipe up to the next worker. It dropped on his head, caused traumatic brain injuries, damaged his spine. He can no longer speak and is confined to a wheelchair. And normally this would be workers' comp, but the safety was so bad and the supervision was so lax that it was considered an intentional tort and was brought into the trial. And the attorneys were very effective in showing that this is actually not a workers' comp situation. And the jury awarded $411 million. It's a serious tragedy. And I'm going to go a little bit quicker on these.
Chef Toby Rodriguez of Acme Oyster House will begin in 5 minutes. Please head over to the cooking demo stage now.
Don't leave yet.
This is another serious tragedy. Tramble versus Briscoe. Originally, the jury awarded $219 million. And I think it's important to reckon with these cases head on. It's not about how tragic these cases are or to cast aspersions. I would never want to trade places with Tramble. But the point is, when does the compensation go into something else? Remember, these are compensatory damages, not punitives. This is an accident. A line truck crashed into an ambulance trying to get onto a highway. It's a horrible accident, but it's not on purpose. And about 3 weeks ago, the Third Circuit Court of Appeals agreed and reduced it to $84 million. This is Carmouche versus National Union, an award of $26 million. A cement truck rear-ended a mother driving her children to daycare and knocked the mother's vehicle, Carmouche, into oncoming traffic where it got hit by another truck and split the car in half, and tragically, she saw her own daughter die. Like Tramble, it's a tragedy, and it combines the most emotionally charged elements. But justice needs to be served, we understand, but elements make it difficult to separate legal compensation from just a sense of the jury saying, let's just make it right with the biggest number we can think of. And this precedent of elevating agonizing, sympathetic presentation over clearly demonstrated damages just ratchets up the verdict floor.
Okay.
I think we got a couple more minutes. I'll try to run through these. Mariano versus Alexander, 18 million. Now this is not notable for any tragedy or major medical expenses. This is a man who got hit by a sports reporter for The Advocate, and they were able to bring, the Advocate journalist was going to pick up his laundry, but they were able to bring in the whole policy of the newspaper, which is $16 million plus these other parts, and he was awarded $18 million for what, when I started out as a lawyer 15 years ago, would have been a $200,000, maybe $100,000 judgment. $18 million.
That's good. You don't have to do the last one. Don't do the last
okay.
one.
And that's about it. Just show you this last one. And I'm going to hand it over to Alan to wrap things up and close it up.
I don't want to move in on a great chef's time. As I see him over there, we were walking in, and I said, what do you got to do this afternoon? He said, I got to do a cooking demonstration. And I said, oh, I'm going to be speaking. Well, what time are you speaking at? And we didn't realize that we were going to be almost sharing the stage, but I'm not going to in any way cut into your time. So to wrap things up, I just want to say one thing, and I think about this all the time. When people ask me, well, what can I do about this? What can we do about, tort reform? What can we do about the rising costs of lawsuits, etc.? I'm going to give you one bit of advice. Do not call me up to get out of jury duty, okay? That's my advice for the day. Go serve on a jury, because if you don't, it's not going to be a jury of your peers. So everyone out there, think about it. You may feel like it's onerous, but please take that little bit of time, do your civic duty, serve on a jury. Thank you for your time today.